When businesses send their employees cross-border to do business, that usually in order to effect that process, you get a visa, you go through the process of having the correct documents and the correct identification in order to travel cross-border. That person that's traveling on behalf of the business may also be in possession of information of that business in respect of whom he or she is traveling. Now, the personal information is any information that can identify, one, the individual that is traveling, or two, the individual on whose behalf they are traveling, and that is usually the business. What you need to know is that processing of personal information, even when the person is abroad, is subject to the laws in South Africa, because the responsible party or the person processing that information, i.e. the business, is here in South Africa. That's one. Number two, what is very important is that the person traveling into another jurisdiction, for example, the UK or Europe or the United States, may be subject to another data protection regime. Now, when you go into the European Union, for example, as of next year, 2018, something that's quite topical now is GDPR, which is General Data Protection Regulations. They come into effect in May 2018 and may apply to persons transiting through the European Union and whoever's processing that information. So if you are processing information on behalf of someone traveling in the European Union outbound from South Africa, you may have to have regard for that personal information or the data protection processing requirements of another jurisdiction. The other important aspect is inbound, where, for example, as a business, you are accommodating or you are hosting someone traveling from abroad to your organization in South Africa. Now, the GDPR has something called extraterritorial application. It means that an EU citizen will be subject to the laws of the GDPR no matter where they are in the world physically. So which means that we may have a situation where that information that applies to the individual traveling into South Africa outbound from the EU will have to comply with GDPR here in South Africa. So your environment will be POPI compliant as far as South Africans are concerned, or to whom, who's traveling and is subject to the Act. And because the EU citizen is subject to the GDPR, you may have to comply with that here in South Africa. There's no one size fits all, and there's no black box. There's no one solution that will solve the POPI challenge. What it needs is someone to look at it specifically and to address it in the context in which it arises. So the first thing that organizations can do is engage the right resources, engage the right help to help you to understand and to assist you to understand the provisions of the Act and the way it obligates, or the obligations it places on you, okay? But generally, what we can say is, if we need to try to understand it, it's based on a number of principles, okay, of good governance in terms of processing personal information. Those principles here are called the data protection or conditions for the lawful processing of personal information. Depending where you go in the world, it's called data protection principles. But they are the principles in terms of which, the minimum requirements in terms of which you have to process personal information. So that's what the heart of POPI is, right? These are global, generally global principles. So wherever you go wherever you go in the world, you won't be out of tune or out of step, because it's international, and that's why we say it's world class or for world standard. So it uses that, and the POPI Act prescribes that you comply with those principles in a number of ways, but two main ways. One is organizational, that is your policies, procedures, checklists, standard operating processes, training, to ensure that your organization from a human perspective understands and complies with it. Okay? The other half is the technical requirements. Now, POPI cuts across all aspects of your business. Okay, from the data subject, which is your customers and your clients, all the way up to where that information is processed and who it's sent to. So the other half of complying with the Act is the technical requirements. So the specific hardware, software, networking requirements, how you manage your assets, because your assets contain your personal information. Bring your own devices. If you and I bring our devices to work and we're accessing our emails, that device needs to comply with POPI. So there's a technical requirement, there's an organizational requirement. Both must be complied with. But there's no one size fits all. The way you go about doing this is engage the right resources. The right resources is a combination of people that understand the legal frameworks and the IT frameworks. You need someone to look at this specifically. Whether it's someone that's in your environment that their mandate is kind of increased to include POPI, or whether someone else is redeployed into taking or looking at POPI and the protection of personal information. However an organization deals with this, the one thing we can say for certain is that someone needs to be looking at this and focusing on it, whether it be someone in your team or whether it be a third party that's doing it, or whether it's a combination of both, which my experience has shown is the best way to do it. That's the way you're gonna comply with POPI. But you're going to have to put in a focused program that looks at POPI. You will not be able to comply by buying certain equipment, by looking at or obtaining one piece of advice. It is continuous. It is ongoing. Compliance is a go, no-go exercise. In other words, any single flaw in your environment means that your environment is not compliant with POPI.